Hello, and welcome everyone to our panel on the EU's leveling the playing field initiatives, how your brand can be affected. Those of you who participated in recent luxury law events may remember that our firm organized in recent years panels on the internal EU competition rules and how they could affect the distribution of your brand, supply chain issues and distribution issues. This time we want to broaden the area of the law and take a wider look and talk with you about the international trade relations of the EU with third countries. Discuss how current measures, but also pending initiatives that all could be brought under the umbrella level the playing field for EU firms can affect your brand. And we want to discuss both existing measures, how they already create situations for brands that could affect how you do your business, but also pending initiatives and discussions, so you are aware of issues that likely will come up in the future and may create risks for the way you operate your business. And that's certainly true also for a very interesting initiative right now that would create something like a hybrid instrument that would empower the competition commissioner and the competition enforcers within the European Commission to essentially check foreign players for subsidies, so financial contributions by third countries to entities in third countries that may nevertheless have an impact on the internal market. And again, we want to show you how this sort of hybrid instrument that combines trade and competition rules could affect your brand. Last but not least, since the UK will soon become a third country from the EU perspective, we also want the use the opportunity to discuss with you how some of these questions may in the future come up in the relationship between the UK and the EU. To discuss these issues with you, we've assembled a panel from our firm that includes both members of our trade practice group and our competition group. So to introduce them, you will hear from Philippe de Bael, the head of our trade practice group, Isabelle van Dam, who is also a counsel, a senior member of our trade practice group, Alex Stradakis, a new partner in our firm who heads the UK competition practice for Van Bael and Bellis. And then I will also contribute. I'm also a member of Van Bael and Bellis' competition group. So now I lost control of. Here, just a quick outline again of the topics you will hear from us. I already mentioned them in the introduction. And with that, I will turn it over to Philippe and ask him to explain more about the concept that provides the framework for our presentation. Philippe, you're on mute.
Okay. Thank you, Andreas. I think you can go already to the next slide. So good afternoon to everybody. So let's maybe start from with saying that we obviously live in the quite challenging times, not only because of COVID-19, but also because we are moving really away from what in the past was a kind of free trade consensus to a new normal, whereby that the notion of free trade as being good in itself, having value by itself, has been seriously challenged. But let's just first look at where we are coming from. I think for many years, and certainly in the EU, these two quotes that I have put on this slide really catched or caught the consensus in Europe, and which was actually driving the trade policy of the European Union. So the 2016 program of the EU on trade was called Trade for All, believing that actually free trade would bring benefits to everybody. And there you see that these benefits can actually be identified from a purely economic viewpoint. And what is the quote by Paul Samuelson: free trade promotes a mutually profitable division of labor, makes possible higher standards of living all over the globe. And also the idea that free trade was actually an agent for peace. And there we have an older quote from Montesquieu, which says that actually if countries do trade together, then they will become interdependent and they will be less likely to engage into conflict. Now, both concepts of free trade as being economically good and increasing the standard of living all over the globe, and the fact that it's an agent for peace, have been challenged, because people have more and more realized that actually free trade has also a number of negative consequences, which can be economically, because certain industries are no longer competitive, can be socially, because free trade and competition may lead to an erosion of labor rights and the non-respect of labor standards. It may lead to environmental pollution. So the notion that we actually, through free trade, create also a lot of detrimental effects has gained traction in recent years. And what we see now, and if you can have the next slide, is that more and more free trade and the right to trade is made conditional on the adoption and the respect of a number of rules, which are not by itself trade related. More and more the EU expects that if you want to trade with the EU, you follow the rules of the EU as far as the environment is concerned, as far as social rights are concerned, respect for human rights. And what we see that this kind of, which is called sometimes the Brussels effect, that the EU is trying to spread its own regulatory framework to its trading partners in order to ensure the respect of these kind of social and environmental rules. This is in fact a kind of attempt to mitigate the negative effects of free trade. And what we have seen in the past, certainly in the context of the generalized system of preferences, whereby the EU gave benefits to developing countries, that you would get additional preferences, initial benefits, if you followed, for instance, the International Labour Organization core conventions, or whether you were respecting environmental rules. So initially, the approach of the EU was to give you something extra if you complied with European rules, the so-called GSP Plus system. What we have seen now is that actually the EU no longer see this as something that you can get something additional, but actually a requirement in order to be able to trade with the European Union. And this has changed into the concept really of level playing field. And that means that the EU considers that you should not be able to compete on the European market, that you should not be able to import your products into the European Union unless you are subject to the same rules as the European companies. And it's no longer only the international rules like the Paris Convention on the Environment or the International Labour Organization rules which apply, but for instance, rules on data protection, rules on chemical products, REACH, etc. So what we have seen now is that more and more the European Union will make you pay a price as a third country to deal with the European Union. And this price will be that you will have to adopt a number of EU regulations, and not only in the field of trade, in a lot of different areas of the EU law. And also this kind of concept of level playing field has actually entered into the world of the competition policy. And I think, Andreas, that you have to say something on that further.
Yeah, thank you, Philippe. If I just add sort of a little gloss here from the competition perspective. So traditionally, you've seen competition law very much as a EU-focused instrument that ensures that markets within the EU work well for consumers. But as Philippe already mentioned, it's this notion that competition law enforcement actually has also this international third country dimension, can be used to create a level playing field for actors outside and within the EU, is something that clearly has sort of emerged also in competition law. Just to give you a couple of examples that you're all aware of. Think of the state investigations, high-profile case that the Commission brought and currently lost against Apple in Ireland, accusing Apple, but also a number of other international players of benefiting from tax regimes that disadvantage their European rivals that don't have the same opportunities to create tax minimizing measures. Another example that you may well be aware of goes a little bit in the reverse direction, where in the wake of a high-profile merger decision by the European Commission prohibiting the merger of the high-speed rail networks between Siemens and Alstom, a very serious debate started whether EU competition law, merger control law should not also include the aspect of how European firms can compete against their global rivals, and whether merger control law should also be a tool that permits European industry to become a more effective global competitor. A third example that all of you are sure aware of is the way the EU is currently approaching and wants to approach in the future digital platforms. An already existing example would be data protection, GDPR compliance, where you've seen clearly an effort to force global players, global owners of digital platforms to adjust their business models to European data protection laws. But more generally, if you look at how currently competition law is being enforced, or how it is discussed that it should be enforced, there's also very clearly in competition law now the notion that competition law can help European rivals to compete more successfully against their global competitors, especially the large US platforms. So clearly we see in competition law also more and more this notion that there is an external aspect, a way to help European firms to compete more successfully. With that, we'll turn it over to the more specific trade measures that currently exist or initiatives in this area.
Yes, thank you, Andreas. Obviously, what has all of this to do with the brands and the branded products and luxury products? There are basically two aspects, and I will deal with the first aspect before turning it over to Isabel. Luxury goods and branded products are actually the ideal targets for retaliatory measures. This is now becoming an increasing risk because, as I mentioned in the introduction, the free trade consensus has really broken down. So people have become, and countries have become much more critical of free trade, and they do not hesitate anymore to take protectionist measures in order to defend what they see other societal values. I think in COVID-19 we have seen countries adopting export restrictions on pharmaceutical protective equipment, medical equipment, or trying to block the export of certain pharmaceuticals, or force companies to reshore production. So what we see is that a number of quite a significant number of countries have become much more protectionist and are adopting protectionist measures. And this is something which comes at a time where we have seen that the WTO dispute settlement mechanism has actually broken down due to the US boycott of the appellate body and blocking the nomination of judges at the WTO, we see that there is no clear system anymore to resolve this kind of protectionist measures in the context of an organized dispute settlement system. So what we see then is that many countries then unilaterally start adopting retaliatory measures. We have seen the US, for instance, adopting duties on steel and aluminium, and then the EU reacting to that. We have the effect of the Boeing Airbus case, where retaliatory measures are adopted. The EU has now adopted the proposal for what we call the EU trade bazooka, whereby that the EU can impose retaliatory measures on countries which refuse to engage in international dispute settlement in order to solve trade disputes. So we see this kind of disputes increasing, and at the same time, a lot more retaliation. Now, typically, if you retaliate, you have to make a list of products for which you want to raise the duties, or which you want to impose punitive duties. And if you do that, you always have a big reaction from people who import this kind of products. And they will say, well, if you impose punitive duties on steel, then our cars will become less competitive, or cars will be more expensive, or refrigerators. Or if you impose punitive duties on, let's say, petrol or oil or petroleum, then the car fuel, it will have a huge impact, economic impact. So in the end, when you go through the list of products on which you can impose punitive duties and for which there is no user industry which is likely to complain, you end up always with the same categories of products, which is Scotch whiskey, Italian handbags, sport cars, French cheese, wine, and then this kind of luxury products are then typically the target of this kind of retaliatory measures. You get extra duties on that. Now, a very worrying evolution now is that a number of countries, and also the European Parliament, is actually pushing to what we call cross-retaliation. That instead of when someone imposes the duties on your products, that you then impose also duties on imports from that country, you will say, let's do something different. Let's not impose tariffs, but why don't we suspend the intellectual property rights given to the products exported by that country? For instance, and that is a case which actually happened, Ecuador, in a conflict with the EU about the import of bananas, actually suspended the copyright rights of European artists. So Julio Iglesias could no longer get his copyright fees from his songs when they were played in Ecuador. And this kind of suspension of intellectual property rights is really something that is being debated and could seriously affect branded products in the future. Isabel, over to you.
Thank you very much, Philippe. Now, putting aside trade wars, as Philippe already outlined, the core focus of the EU's trade policy is becoming more and more level the playing field. And the way we see that is that it's very much a code word for conditionality and reciprocity. Conditionality means that there are conditions for obtaining the benefit of market access. Reciprocity meaning that the European Union really expects that other countries will adopt policies similar to those of the European Union. And the European Union now clearly states that it is unfair that products manufactured in the European Union need to compete with products manufactured elsewhere under conditions that are less strict in terms of environmental protection, climate change policies, labor conditions, or human rights conditions. So the European Union's willingness to open its markets now depends on whether those goods were manufactured elsewhere in environmental and labor law conditions that meet a minimum level of protection that satisfies the European Union. Now, that is not entirely new, this idea. But what's very new is that the European Union is now stating that these conditions are mandatory, and it's taking much more enforcement action. So it's becoming a bit more aggressive in enforcing those conditions. And to take an example, If you manufacture textiles in Southeast Asia, then the wages and the labor conditions there might become a reason for the European Union to restrict market access as long as those labor conditions are not improved. And this has caused the European Union very recently this year to suspend tariff preferences for products manufactured in Cambodia, including textiles, and to also start litigation against Korea for failure to comply with ILO standards. The same level playing field strategy or policy underlies also proposals for carbon border adjustment tax or for a digital services tax. The carbon border adjustment tax would mean that the European Union says that products that arrive at the EU border and were manufactured in countries that don't have a strong climate change policy, have not internalized certain costs. So the European Union wants to take some corrective action. Some of these initiatives will result in concrete measures applied at the border. But there are also more subtle mechanisms that the European Union seeks to introduce that apply behind the border, once you have access to the market and you want to sell your products on the EU market. And here we would note two developments. The first one is that your ability to mark your products as, for example, made in France or made in Italy, can very well depend on manufacturing conditions elsewhere in the supply chain. The second development is that increasingly at EU level, but also at member state level, that the assumption is that the consumer should know about the conditions in which your products were manufactured. And what we see at EU level, at member state level, but also increasingly private standards from large retailers, is that they are requiring more detailed labeling requirements that no longer have to do with stating solely the origin of the product and its composition, but also the conditions in which the product was manufactured. And the overall result of these initiatives is that accessing and the EU market and selling on this market will become more burdensome and will become more expensive. And that means that your companies will have to enforce and increase efforts in compliance risk management in respect of products that are destined for the EU market. And this compliance risk management can also affect the development of your reshoring strategies. Finally, this shift in policy is also kind of resulting in very concrete initiatives on the European Union in terms of enforcement. And Philippe has already mentioned a few of those initiatives. Another one that I would like to add is the creation of a new function in the Commission of the so-called Chief Trade Enforcement Officer. And this person's task will be primarily to monitor compliance of the EU trading partners with their obligations under trade law. And those are no longer core obligations only with respect to tariffs or import bans or subsidies or anti-dumping measures, but they also increasingly contain obligations with respect to sustainable development, environment, and labor law. So in sum, I would say that the Brussels effect is no longer an indirect effect. It has become a very visible effect, resulting in concrete actions that may affect your brands. Now, so far, we have spoken primarily about level playing field initiatives that target specific types of products or maybe particular sectors. But the European Union is also moving forward with other initiatives that would cover or apply or affect businesses regardless of the products that they manufacture or seek to sell. And this brings us to the next section of our presentation, which will deal with the European Union's proposal to tackle foreign subsidies that distort the internal market. And Andreas and I will cover this topic. So in the European Union, basically, if you receive any aid given by a member state, or you propose a merger, or you want to acquire an EU asset, this is all intensely scrutinized in terms of the effects of these actions on the conditions of competition in the internal market. However, in other countries, the same rules don't necessarily apply. And also the current toolbox that is available to the European Union does not allow it to address and remedy the effects of foreign subsidies in the internal market. And therefore, the European Union, in particular the Commission, published a few months ago a white paper on foreign subsidies. And in this white paper on foreign subsidies, the Commission states very clearly that it is unfair that without any oversight, foreign governments can, through their foreign subsidies, distort competition in the EU market. So the Commission is proposing an entirely new toolbox. And this new toolbox is organized around different modules. And today we'll focus only on Module 1 and Module 2. And I'll speak about Module 1, which is the general module affecting kind of all distortive effects caused by foreign subsidies. And then Andreas will talk about more specifically the proposals that will affect mergers and acquisitions. Now, Module 1 involves that if, for example, your Chinese-owned competitor seeks to build a new manufacturing plant in France and benefits from Chinese monies, basically, then the European Commission might start an investigation and take redressive actions. The European Union can start this investigation without the prior filing of any complaint. It can do this of its own motion, and it will check whether there is a foreign subsidy, whether this foreign subsidy distorts the internal market, and unless it sees that this investment is of particular value to the European Union as a whole, it can take redressive actions. And these redressive actions can possibly take very different forms. It can go from a requirement to pay back the money, let's say to the Chinese government or to the US government, or it could also involve that you will be required to stop your business in the European Union, or maybe some of the licensing obligations will be suspended. The European Union proposes a very wide concept of subsidies. And it really means that any financial benefit that you might receive from a foreign government could potentially cause you to be, or your competitor to be investigated by the Commission. There is a minimum threshold of 200,000 euros, but overall that is a very low threshold. So you can easily fall within the scope of these proposed new measures. I'd like to emphasize that these measures will affect all markets and all sectors, and especially your ability to supply services in the European Union or to manufacture luxury goods in the European Union can be affected. If you primarily manufacture outside the European Union and then import those products within the European Union, then you probably will fall outside the scope of these measures. But such subsidies can be affected by other existing EU trade defense instruments. Now, it is undoubtedly the case that by design, these proposals are primarily aimed at responding to Chinese subsidies that distort the EU internal market. But it's important to take into account that these proposals would affect all subsidies given by foreign governments. So also, for example, if you receive monies, financial benefits from the United Kingdom or from the United States. And in fact, the European Union will want to avoid that it seems to be discriminating against China. So you can expect that the European Union, if it goes forward with these proposals, will seek to enforce it also with respect to non-Chinese subsidies. Before I conclude, I would like to note that you have to take into account that there are significant risks also with the European Union's strategy. Even if, for example, you are an EU manufacturer who does not currently receive monies of foreign origin. Because first of all, there can be a snowball effect. Other countries might like this idea of the European Union because they're also concerned about the effect of foreign subsidies. And what we see is, for example, Japan is quite interested in these proposals. So that would mean that if you're an EU manufacturer receiving monies from, let's say, the French government, but you also kind of want to expand your business into Japan and invest there, that you might then become subject to the scrutiny of the Japanese authorities. The second risk, and this brings us back to the ideas put forward by Philippe, is that some countries will strongly disagree with these proposals of the European Union, and they might seek to retaliate. And in that event, again, luxury goods could be part of the collateral damage of such a trade dispute. I'll now turn to Andreas to discuss the second module. Thank you.
Thank you, Isabel. Yes, so as Isabel mentioned, there's a second dimension in this policy initiative, and that affects would affect transaction M&A activities, including M&A activities involving brands and players in the luxury industry. Now, of course, M&A for brands and including producers of luxury products has been subject to control under EU competition laws, merger control law, or national merger control laws for a while. But this initiative would introduce a scrutiny of another aspect of these transactions. And essentially, the inquiry would be whether the transaction has been facilitated by foreign financing, where the transaction is used to acquire a EU target. And the ultimate question would be whether, if there was such a foreign financing facilitating acquisition of an EU target, whether that could lead to a distortion of the internal market. And that could be, foreign financing could be direct financing, so essentially providing financial support to the acquirer, in which case there could even be a presumption that this leads to a distortion in the market. But it could also include other forms of more indirect financing that benefit the acquirer and affect its ability to acquire a new target. So it would be an additional stream of inquiry that has to be taken into account when you as a brand are involved in M&A activity, either on the acquiring side or actually the side that's being acquired. So what would that mean? In principle, that would mean that in addition to the review process that some of you may already be familiar under traditional merger control law, there would be a second parallel but largely independent inquiry on the foreign subsidy aspect. Now, you may know that many times, typically, transactions in the brand space involving also luxury good players tend to raise very, very few competition law issues. So many of these transactions are reviewed by the European Commission, by the national regulator, but generally do not raise a significant range of issues. But here you would have a second review. And you know, even in merger cases that don't raise issues, the review process can be very, very burdensome. I just remind you of the currently pending LVMH Tiffany merger, which has been before the European Commission for more than 8 or 9 months and still is not being notified. And the Commission is still asking for investigation, for additional information. So the entire process can be very laborious. And with this second module, you would find a second process with a second notification, the requirement to provide information. During the investigation, you would not be able to close the deal. So it would really be a parallel process, and that could also affect M&A activities. Of course, that would also require to expand due diligence prior to actually agreeing on a transaction, because you may want to inquire whether a potential acquirer has sort of a foreign subsidy problem, which then could add additional time in the review process and may make the acquirer a less attractive business partner. So all these complications would be added. Plus, there is a risk, of course, that if you have several investigations in parallel that address different concerns, that you may have different outcomes. If you look into whether a transaction causes harm to competition, you may decide that it's not the case. But if you look into the question whether a foreign subsidy distorts the internal market, you may have another outcome, another type of remedy required in this case. Or you may have a merger investigation that relatively quickly concludes that there is no problem, but something that a foreign subsidy investigation that requires a lot more information and a process that's drawn out and may result in remedies which you would not consider necessary under a merger review regime. So exactly how this instrument will be shaped, it's still a question of debate. But if there is this additional review aspect in M&A activity, you have to be prepared to address also foreign subsidies issues as part of a regulatory M&A review. Good. with that, I want to turn it over to Alex, who, as I said at the beginning, will shed some light how all these questions will affect the UK once Brexit actually has happened.
Thank you very much, Andreas. And as you can imagine, Brexit is a reality on top of COVID and other challenges we have to face. And I suspect the million-dollar question is what is happening and what will happen in terms of will there be a no-deal Brexit? What is the state of negotiations? It's a huge question. It's very difficult to guess what the outcome would be. Maybe we're heading for a no deal, given that right now state aid and fisheries seems to be very thorny points, and I don't see how progress will be made in such a short period of time. That said, who knows? But I think what Philip and Isabel said in terms of the EU efforts in terms of leveling the playing field provides a perfect segue in order to understand the dynamics in terms of Brexit. And if you want to follow the rationale of why Brexit needs to take place, is to move away and create your own trade and competition policy, whilst at the same time the EU is pushing for more of a level playing field if access to the common market is to be provided. So it's a very interesting tug war, and who knows where this will end. What is for sure is that when you were used in the past and still to be dealing with one regulator in terms of your competition and trade matters, especially your competition and trade, especially on competition matters, now you will clearly have two. And echoing what Andreas has said in terms of complexity of another regime on top of the competition regime, you'll also have to deal with an extra regime, the UK merger control regime, which is ours, well-resourced, intensive, and intrusive, I would say, when it comes to scrutinizing deals, even kind of deals that perhaps the EU would not be interested in. So bear in mind that additional administrative and burden and associated costs. And then another huge question is what would be the nature of the UK state aid control regime, if any. And this is very much linked into the kind of agreement or absence thereof when it comes to an EU-UK trade. So as you can imagine, the EU insists that if any meaningful access to the common market is provided to the UK needs to adopt a very similar, if not identical, state aid regime. Obviously, the UK wouldn't like to be bound by Commissioner Vestager and the European courts when it comes to the application of the state aid rules, even to follow those kind of precedents, because the whole point, I suspect, from the UK side of Brexit is to be able to have their own industrial and subsidy policy. So again, this is a huge unknown. And if you would ask me what is the future of state aid in the UK, it's a huge question mark. I do not know what the answer is. There needs to be some sort of subsidy control, but it's a raging debate here in the UK and also between the EU and the UK aspects. Last but not least, I think what is very relevant for you is the future of parallel trade when it comes to the post the end of the year. And the situation is quite complex and uncertain. The UK, with its policy, has more or less adopted an asymmetric exhaustion principle, meaning that goods can come from the EEA into the UK, but from the UK into the EEA as an IP holder, right, you can object to the parallel export. How the CMA and the European Commission will add a gloss on that from a competition perspective is a big question mark. So I think if you would consider treating or moving away from the current consensus of free trade between the EU and UK in terms of your IP protected goods, I would highly advise you to think carefully and get legal advice up to the point of exit and thereafter. And I wouldn't be willing to be the first, essentially, to test that proposition. I would like to see more guidance from all involved. So that's my 2 pennies worth. I would like to very much thank you for your attention. You can see our contact details and emails, and we would very much like to invite you to ask any questions, email us, or call us. And I thank you very much for being with us today. Thank you.